ET Final Score is brought to you by Ashley Furniture.
Mr. Castle, your client will stand. Court takes notice of the pre-sentence report that was prepared and the evidence that's been presented here in open court today. I've considered the full range of punishment in the case. I think I've mentioned each time I'm asked to do an open sentencing that I used to explain my rulings with appellate courts due to some of the appellate lawyers claiming the court wasn't considering the full range of punishment based upon some of the statements the court typically made back in those days. I don't explain my rulings at all any longer. I still think it's a beneficial thing for our process in open sentencings, but again, I'm just following the directives that the courts of appeal have given to me. The court has considered the full range of punishment. The court finds that it's appropriate to find the defendant guilty as she has pled guilty to the charge in this case, that being 0071433-11. I've considered probation. I don't find it to be appropriate. I will state that there was no explanation given, but the pre-sentence does show that in 2009, in 0072189-09, another similar charge was indicted and pursued in this court, and then it shows in May of 2010, apparently the state chose not to carry that forward for whatever reason, but that is before the court as well. Sentencing here in the second case as well, Ms. McSwain, the court has considered the evidence, as you heard me say in the first case, just for record purposes. I considered it in this case as well. I've considered the full range of punishment in this case. I find that this setting, or not setting, but rather the sentence I gave you in the first case is appropriate in this case as well, particularly in light of this case having the 7-1245 matters. The court therefore finds, based upon your plea of guilty and evidence presented, that you're found guilty of the charge set forth in this particular indictment. The court assesses punishment on that finding of guilt at 6 years confinement in the institutional division. Not going to assess a fine in this case. The court does tax your taxable court cost in this case. The court does, in this case, since it's part of the terms of the open plea agreement under the Texas Penal Code Article 1245, I do take into consideration the other cases that the court, that the state threw in, I guess is a good way to put it, in relation to the sentencing of this case, that being cause numbers 007-1435, 36, 37, 38, 39, 40, and 41-11, which you acknowledged your guilt upon at the time you entered your plea of guilty back on July 31st. The court does take those into consideration as a part of the punishment in this case.